today and argument, and we've completed both, so it's time for me to render judgment. The statute that matters today is Louisiana Revised Statute 14:108. Specifically, it says resisting an officer. Resisting an officer is an intentional interference with, opposition or resistance to, or obstruction of an individual acting in his official capacity and authorized by law to make a lawful arrest, lawful detention, or a seizure of property, or to serve an lawful process or court order when the offender knows or has reason to know that the person arresting, detaining, seizing property, or serving process is acting in his official capacity. And specifically, under B1c, this is being accomplished in this matter by a refusal by the arrested or detained party to give his name, make his identity known to the arresting officer or detaining officer. So first thing we have to cover is reasonable suspicion. Did these officers have reasonable suspicion to even approach you? And I have heard testimony today from Rosalind Parker, who mentioned that you had come into the library carrying 2 large bags, apparently backpacks, that you were angry looking, that you were checking exit doors. She may or may not have used the word casing. I don't know, but she clearly said that you were checking all the exit doors in the building, and you went to the 3rd floor after realizing it was upstairs and went up there and checked it, and it was locked, and came back down. And her testimony was that she was worried that in the era of mass shootings, and specifically mentioned the Boston bombing, that backpacks being left in places or suspicious people should be checked out. Then we have the testimony of Carlo Jimenez, who stated that he also saw the 2 backpacks, but his concern was the loud banging that occurred. Apparently, there was some sort of loud banging that made him worry that it could have been a weapon of some sort. He also was scared of your tone, of your voice, and your demeanor, and in fact, he used this term that you were intentionally suspicious. All this was relayed through to Nakata Scott, who is the dispatch officer. Now Mr. Jimenez's testimony was not relayed through her, but Ms. Parker's was, and this information was then given to Officer Davis and Favors. So Officer Davis and Favors appear on the scene. Having gotten this information and then proceeded to talk with Parker, see Jimenez, and him looking to both of them as if he was fearful, and then proceeded upstairs or to your room to discuss with you. I think they have reasonable suspicion. I think that they have been given that in that they have heard things, they have seen things. They communicated that to the officers. This was not an officer of seeing you on the side of the street and stopping you and hassling you for whatever reason. This is an officer that was summoned based on 2 lay people's opinions or worries of violence, and there is no security at a library. It's a fairly vulnerable place. And so, as a result, they reached out and contacted the people they are supposed to contact, which is law enforcement. Law enforcement then took it to the next level and said, well, we're going to investigate, and they go upstairs to meet you, and you have cameras on and refuse to give your name. So you know that's where this crime comes in. And that's where this charge comes from. So the question becomes, yes, did you do that? Did you refuse intentional interference with an officer? Well, yes, you refused to give your name by my count. About 4 times, not 5 times. It could have been 5, but I noticed 4. I think 2 from Davis, 1 from Miller, and 1 from Favors. Did you obstruct an individual acting in their official capacity? Yep. They both identified, all 3 identified themselves and Natchitoches Parish police officers. And were they authorized to make a lawful detention? Yeah, they were. And did you know that they were acting in their official capacity when they do so? I think so. They both, all introduced themselves. What's ironic is that you asked them in the video their names. I don't quite get that, but you were sure that you knew who they were even though they did not know who you were. And then again, the subsection, B1c, says did you refuse? Yes, you refused by the detained party not giving his name or making his ID known. It is not required, as is often messed up in this case, or misstatements, that an ID has to be provided. An ID does not have to be provided. This is strictly them asking your name, and you refuse to even give it. So then I get to the why, and that's my biggest concern here, is that this court believes that you intentionally created suspicious circumstances. I don't know any other reason to suspect why you would go and check all the doors to a building. It's incredibly suspicious why you would go. If it was a fire concern, why you would go to higher floors. That doesn't make any sense. If you were really worried about a fast exit because of something could happen to you, then you would stay on the 1st floor. But instead you, in fact, Even tried to get to the third floor, so I don't think there is any rational explanation for that or the banging or, to be honest, why you're recording yourself in the library. I don't understand that. I don't know why you would set up video cameras if you are, as you said earlier, normally using the library. I don't know anybody who sets up video cameras of themselves while they are normally using the library. I think you created this circumstances so that you would create reasonable suspicion so that the police would be summoned, and they were. And so at that point I find it difficult for you to walk away from the circumstances and claim you have no idea why the police would come, why they would contact you, why would they want your information, and why they would detain you. So I hereby find you guilty of resisting an officer. We have heard testimony today and argument, and we've completed both.